courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial, save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution.
Abaana baffe aba NUP abaagaana okutuka olukizi ne bagaana okwetonda ne bagaana okukkiriza emisango bazira. N'olwekyo abo tubeebaza, tuyimirira nabo, bagenda kufuluma era tubaagala out today.
So for us as NUP, we are very, very delighted today because, as you know, the military court has been used to persecute, not to prosecute, but to persecute over 2,000 of our supporters since 2020. Over 2,000 of NUP supporters have gone through that court.
Omusumba ye n'asaba n'agamba bagawugule gagende wakumuguma 13
era mbyagalira ddala pulezidenti wange
betwasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka
Parliament has a broad legislative mandate under Article 79(1) of the 1 and 3 of the Constitution to enact laws in the interest of national peace, order and good governance. Article 210A and B further empowers Parliament to enact laws that govern the UPDF's organs and structures, as well as its discipline. Having found that the General Court-Martial is indeed a subordinate court of judicature, it follows that its establishment under the UPDF Act and the delineation of its jurisdiction therein was well within the remit of Parliament. However, the scope of that jurisdiction is a matter of contention before this court. I find that the term service offence in Section 1 of the UPDF Act would encompass the offences created under Part 6 of the UPDF Act in relation to the persons delineated under Section 1171A to F of that Act, as well as offences under any other act that are committed by the same category of persons. Hence, the scope of service offences in question restricts the inclusion of civil offences to those cases where the civil offences are committed by persons that are in active military service as delineated under Section 1171A to F of the Act and on field operations. Persons that are not in active military service but only became subject to military law by dint of subsection 1171G and H of the Act would not be tried for service offences in the military courts. I now turn to the contentious question of the jurisdictional scope of the General Court-Martial over civil offences. I do acknowledge the position taken in Attorney General versus Joseph Tumushabe that there is no provision of the Constitution that restricts Parliament from vesting a subordinate court with jurisdiction that is also within the purview of the High Court. For present purposes, however, I take the view that this lacuna should be interrogated with regard to the special character of courts-martial and existing international safeguards in respect of military courts. Section 117(1)H of the UPDF Act is void for vagueness and therefore inconsistent with the right to a fair trial as enshrined in Article 28(12) of the Constitution. 5. Service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the objective of the UPDF Act under Article 210 or the legislative mandate of Parliament under Articles 79, 129(3) and 210 of the Constitution, nor in any case are they inconsistent with Articles 28(1) and 44(c) of the Constitution. I shall pronounce my final order as the quasi-retrospective application of all cases pending before the General Court Martial in light with Order 2 above. Respectfully propose the following additional advisory order for consideration. The General Court Martial be substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order.
Courts martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts martial save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts martial be suspended forthwith. An injunction doth issue restraining the instigation, reopening, or continuance of the respondent's trial before the General Court Martial or other courts martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future courts martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings or movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary courts of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant of 1 Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal reform and amendment of the UPDF Act in order to enable the courts of judicature to exercise their mandate of judicial review over the courts martial. In this regard, an amendment of the Uganda People's Defence Forces is required to confer appellate jurisdiction to the apex courts for them to be able to lawfully entertain appeals from the courts martial. The other question Ogwang raises is a requirement to delimit what a service offence is during peacetime. I propose that a soldier who commits a civilian offence when he is off post and away without pass leave or award should be arraigned before the civil courts, civil as opposed to military courts. the cross appeal succeeds, the main appeal succeeds in part. I make no order as to process.
Suffice to say that any delay in dispensing justice is always regrettable, whatever the cause. The larger principles at play in this case are the age-old principles of the jurisprudence of criminal law. It is universally accepted in the common law system to which Uganda subscribes that the presumption of innocence is the bedrock of our criminal law. And this has been incorporated in the 1995 Constitution of the Republic of Uganda under Article 28(3)(a), which states that every person who is charged with a criminal offense shall be presumed to be innocent until proved guilty or until that person has pleaded guilty. In other words, everybody is presumed innocent until proven guilty by a competent court. What we are investigating in this case is whether the court-martial is a competent court to try civilians or anybody else brought before it for that matter. Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution, which reads, in the determination of civil rights and obligations of any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law, close quotation. So the question is, does the General Court-Martial guarantee these fundamental freedoms? The answer, as far as civilians are concerned, has been found to be largely in the negative. In accordance with the doctrine of precedent and in view of an earlier holding by this court, the conclusion in Attorney General versus Joseph Simushabe that the General Court-Martial is indeed a subordinate court as contemplated under Article 129(1)(d) of the Constitution is still good law. Secondly, that Section 117(1)(g) of the UPDF Act does constitute exceptional circumstances under which the trials of civilians in military courts would be justified, and to that extent is not inconsistent with Articles 28(1) and 44(c) of the Constitution. However, I agree that Section 117(1)(h) of the Act is to be found void for vagueness and therefore inconsistent with Article 28(1) of the Constitution. On the issue of remedies regarding matters pending before the General Court-Martial involving civilians, I would agree that they will be remitted to the civilian courts for consideration. And in regard to trial of members of the military, I agree with the recommendations given to the Executive and Parliament to work on the necessary amendments in order to bring the court-martial in conformity with the Constitution. I'm persuaded by the doctrine of prospective annulment as opposed to retrospective annulment, as laid down in the case of Kalistan Dumatela and two others against the East African community, which was applied in the case of Bob Kasango against Attorney General. The same principle was held in the case of East African Law Society and four others against Attorney General of Kenya and three others. The court declined to invalidate amendments found to violate the treaty. Court, however, invoked prospective annulment and declared that involvement of the people in the treaty amendment process would have prospective application. In the case of A against the governor of Upper Hill Prison, the Supreme Court of Ireland held that the declaration of unconstitutionality of the law has prospective effect only. It was further held that the court cannot interfere with final decisions of the courts, even if based on a law later to be found unconstitutional. Otherwise, retrospective annulment or retrospective effect, as termed elsewhere, would create an absurdity which the courts can and should never intend. Dated at Kampala, the 31st day of January 2025.
Applied for appointment as judicial officers to the courts of judicature as established under Article 129 of the Constitution of Uganda must have legal qualifications. It is to be noted that both the General Court Martial and the Courts of Judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law would pass. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court martial. The contradictory position is that while under the UPDF Act, qualification for appointment to the General Court Martial does not require one to have legal qualifications, persons qualified for appointment to the position of a judicial office in the courts of judicature are required to have legal qualifications under Article 142 of the Constitution. Secondly, the conducting of criminal trials in the General Court Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications.
Ekibiina ekitwala bannamateeka ekitugatta ne kitulagira okujja tusoomoze okuvunaana Dr. Kizza Besigye mu kooti eno ng'ate bamuvunaana ne mu kooti y'amagye n'okugamba nti ye nga atali munnamagye talina kuvunaanibwa mu kooti eyo. Ne tugenda mu maaso ku olwo ne tuwangula, naye ne tugamba twayagala nnyo okusoomoza obuwaayiro obwatondawo ekkooti z'amagye zino nga businziira mu kawaayiro oba mu nnyingo ya ssemateeka e210 eyali tekkiriza kuteekawo kkooti, wabula ng'egamba nti muteekeewo akakiiko akakwasisa empisa abasirikale bammwe. Asikaali wayambadde bubi, asikaali tewakubye ekikalu, ebifaanana bwe bityo ng'akapoliisi, akakiiko ka poliisi akakwasisa abapoliisi empisa, n'abasirikale b'amakomera balina akaabwe. Ke kakiiko constitution kebakkiriza okuteekawo, bo ne bakakozesa okunyigiriza abo abalina ebirowoozo ebyawukana ku byabwe, naddala abawakanya effugabbi n'obufutubbazi bwa mutambuzi munnaffe omukadde w'entebe. Bwe twavaawo kwesimbawo okuvuganya kw'omuloodi ono, ne bagamba nti bagende bagambe nti olw'okuba ye ne muganda we Caleb Alaka nti ekkooti ya Tumwine yabasingisa mbu omusango gw'okuginyooma nti nebasasuza eshiringi 1,000 nga za binusu, nti tasaanidde takkirizibwa kwesimbawo. Bwe twamanya enteekateeka yaabwe ne tudduka mu kkooti etawulula enkaayana za ssemateeka n'etuwa ekiragiro omuloodi ono kwe yasinziira okwesimbawo n'avuganya n'akulembera ekibuga okumala emyaka 5 ne guggwa mu kkooti ya ssemateeka, gavumenti n'etamatira n'ejulira. Kakati oba ebadde ng'ekolera ku butamanya buweddewo, Bayibuli egamba nti bali balanga ebyo ebyakolebwa mu biro eby'obutamanya. Kakati ebiro by'obutamanya baba nga kyebadde beekwasa biweddewo, kati bamanyi. Abantu abali mu makomera ku biragiro bya court martial oba kooti y'amagye nga bwe badde bagiyita, okuva n'essaawa eno si lwaleero naye kati ku ssaawa eno baliyo mu bumenyi bw'amateeka n'abalina emisango gyonna egibadde gibavunaanibwa mu kooti y'amagye gyonna gisaziddwamu. baba bakyayagala obavunaana babagambye nti fayiro ezo bazitwale mu kooti eza bulijjo. abo ababadde basingisibwa emisango egyo nga baajulira oba nga bateekateeka okujulira babagambye nti bagende mu kooti zino eza bulijjo zeetegereze ensala yaabwe nga bwe yakolebwamu, ziddemu zibawulirize mu ngeri ey'obukugu. Ensonga kooti kwesinzidde kwe kubeera ze zino wammanga nti bw'oyingira obuyingizi mu kooti y'amagye eyo nga bwefaanana olabirawo obutali bwenkanya. Kati ate bwe gutuuka ku ffe abamanyi olabirawo obutamanya. Ffe abaasoma ne tutegeera amateeka olabirawo obutamanya nga bujjudde bwetimbye ekkooti y'abatambuze bannaffe abo. Ebisaanyizo byabwe temulimu kumanya mateeka. Weetaaga kubeera kintu kimu nti oyambala combat, omanye okuba saluti, oli musirikale. Saabalamuzi alina ne watuuse n'agamba nti nga bw'oyinza okuyita yiyo omulamuzi n'omugamba ennyonyi eyiyo tikka abasaabaze ogende Ethiopia oba genda mu theatre e Mulago kwata ebyambe biibyo omutambuze munnaffe oyo yazzaako abantu olubuto lumuluma lulabika lulimu ekirimu sala okijjemu. Ne batambuze bannaffe bano bwe badde batambula. N'olwekyo tubawa amagezi, tubawabula, tetubasaba. Ebiro by'okubasaba byaggwawo. Free Dr. Kizza Besigye. Free Haji Obed Lutale. Free Counsel Aaron Kizza. Free all political prisoners remanded, our NUP brothers and sisters, and those other civilians remanded on orders of this kangaroo outfit. Don't free them today, free them now.
Paka ennaku z'omwezi 3 omwezi ogwokubiri ye Monday, era basuubira okudda okuwozesa Dr. Besigye ku Monday n'Obed Lutale
Constitutional petition.
Era ku Monday kooti tegenda kutuula, titeekeddwa okutuula, teriyo. So kuba kati balangiridde nti kooti terina buyinza. In fact kino bw'okitaputa kiraga nti kooti eno bagisattuludde, kubanga etteeka lya UPDF erigiteekawo bagambye limenya mateeka obuwaayiro bwonna, kisigadde kiwowongole. Era ne bagamba muddeeyo bwe muba mukyajagala kooti mutereeze etteeka, mukole etteeka eddala erya UPDF eriteekawo ekooti endala. Kati eno eya Freeman Mugabe gye bagambye eriko abatamanyi mateeka abatagasoma, tekuli n'omu asobola gataputa. Bagigambye temuddamu kutuula, temuddamu kukola kintu kyonna. So ku Monday bwana Freeman Mugabe agenda akola ebirala.
Kyetuyinza bagamba nti abaana baffe aba NUP abaagaana okukutuka olukizi ne bagaana okwetonda ne bagaana okukkiriza emisango bazira. N'olwekyo abo tubeebaza, tuyimirira nabo, bagenda kufuluma era tubaagala out today. Maze okusaba Ssaabawandiisi ono atandike okumobilizing entambula egenda okubanona gye bali yonna, era bonna ekirungi tumanyi gye bali, okuggyako bali be baabuza. Abakkiriza nabo tetubasalira musango, tubagamba bugambi nti kaakati nga bwe tuggyewo akakuukulu ke baakozesa okubatiisa, mukomewo tukole omulimu ogw'okutaasa ensi eno. Omukadde tumugamba tokola ntondo, wuliriza buwuliriza amagezi agakuweereddwa n'okuwabulwa, wabulwako okole ebyo by'olina okukola. So ndowooza ebyo bwe binaakolebwa bwe banajja mu Parliament bajja tusanga tujja bbawa kye batalina.
First and foremost, it is not a win for me, Michael Kabazi. It is a win for the people of Uganda. It is a win for the democracy-seeking forces in this country, because the GCM has hitherto been used as a tool to fight anyone that is opposed to the bad leadership of General Yoweri Museveni. So I want to thank my legal team, led by the able Honorable Medan Lubega Segona, Council Samuel Muyizi, Council Alaka, and of course the Lord Mayor, Salongo Elias Mukwago, for the battle that they fought so hard to reach here today. When General Museveni sat with some members of the IPOD back in 2016, he informed them that Kabaziguruka is finished. Yes. That I must finish Kabaziguruka. I was in jail at the time, but I read an article in the Observer where he says I tried to assassinate him and that therefore my end was near. So I thank Honorable Segona who reached out to me and informed me and took over the responsibility of standing with me as my counsel in these matters. Of course, when I was arraigned before the GCM, I refused to accept their jurisdiction over me. And I remember at the time, I told the chairman, Lieutenant General Andrew Guti, that he was not fit to be a magistrate of any sort, and that therefore he had no authority to try me for an offense whose maximum sentence is death. He threatened to hold me in contempt of court, but I held resolute, I held steady, and I said, no, you have no jurisdiction over me. That I did not recognize it as a court of law and that I had no business bringing a lawyer there. And I did not. I opted to file the petitions in the civil court of the in the civil division of the High Court, in the criminal court, and then finally to the Constitutional Court. And here we are today, where the Supreme Court of the land declares here today that the GCM is no more. It is finished. Uganda. Well, ensala ya kooti olwaleero egyaniriza era ensalawo si yange ng'omuntu kinoomu wabula y'abannayuganda ffenna. Emabegako mu mwaka ogw'2016 mujja kujjukira nti nakwatibwa n'envunaanibwa mu kkooti ey'ekinamagye GCM, General Court Martial, nga nvunaanwa omusango gw'okulya mu nsi olukwe. Emisango gye nawakanya nga nkimanyi bulungi nti nze sibeerangako namagye. Sisabanga nako, waliwo okuba nti nali nsabyeko ne bagaana, naye sisabanga nako kwegatta ku magye. N'olwekyo tewali nsonga yonna lwaki baali banvunaana mu kkooti y'amagye. Nagaana okukkiriza okuwoza mu kkooti yaabwe, era ne nsaba balooya bange tufayiringe constitutional petition tetwafayiringa era ne tuwangula. Gavumenti ng'eyita mu ssaabawaabi waayo yawakanya ensalawo ya Constitutional Court n'ejulira mu kkooti ensukulumu mu ggwanga lino, Supreme Court. Era olwaleero ndi musanyufu nti kkooti eno esaze omusango guno mu mazima n'obwenkanya nga yeesigamye ku tteeka constitution ey'eggwanga lino era esazza amazima n'obwenkanya nti olwaleero kkooti mwami Museveni gy'abadde akozesa okunyigiriza naddala abo ab'oludda oluvuganya ng'abavubuka ba NUP abamazeeyo emyaka kati kumpi 4, Dr. Besigye nga si gwe mulundi ogusoose, guno ndowooza gwakubira era ng'ali mu court martial, nti olwaleero Supreme Court egisatuludde egijjeewo era mu mateeka ga Uganda tetulina GCM nga kkooti mu ggwanga lino. Wadde muli mubaddemu akakawayiro ndowooza balooya bakanyonyere bulungi kaga nti it's a subordinate court, naye era nako it has to be reconstituted. Balina kugiza bujja teriiwo mu mateeka era nkubiriza bekikwatako mu bunnambiro abantu bonna abakyali mu kooti abakyali mu makomera ag'enjawulo bateebwe bunnambiro si kyakukolebwa nkya oba ku bbalaza wabula balina kukikola ssaawa eno nga kooti bweragidde.
Council Aaron Kiza added to that list. There is no place for the court to try civilians, and we are glad that has come through very clearly in court. We are glad that the Supreme Court has listened to the voices of Ugandans over time, because the people of Uganda have spoken again and again, and it's important that when people speak, the courts get to listen. We are also glad that it's not just civilians that have benefited from this, but even serving military officers, because a number of them have been persecuted through the General Court Martial, and they had no recourse anywhere. They could not appeal. Because you see, the General Court Martial, they are the complainants, then they are the prosecutors in the General Court Martial. They are the ones that sit on the panel, the tribunal, to determine a matter. When you appeal to, again, a team of military fellows. It becomes problematic, and they also execute the same sentences. Yeah, it is problematic in and of every sense. So we are glad that that has been rectified. Our hope is that now this court order will be followed with immediacy, because many times courts of law issue orders and they are disregarded. People have been freed on bail and they are arrested within court precincts. Many times we've had General Museveni say, "You courts, you want to take us back to those days," and that kind of thing. Our hope is that the court order will be respected with immediacy. Briefly, mu Luganda, bongerako ne Dr. Kiza Besigye, Haji Obed Lutale, Council Aaron Kiza, kubanga tebawagira gavumenti eno kyovudde olabanga bakozesa kooti eno okutulugunya bannansi, bakuteekayo eyo, tokkirizibwa na kufuna kakalu ka kooti, boogezaako okwogera ku nsonga ez'enjawulo, contempt of court ne bakusiba emyezi nti kooti eno ensukkulumu ewuliriza amaloboozi g'abannayuganda g'abannansi abazze bagamba nti kino kikyamu okutulugunya bannayuganda nga mukozesa kooti y'amagye eno, kubanga bannansi tewali nsonga lwaki babeera mu kooti y'amagye. Kino tuze tukyogerako ebbanga eriwera. Kirungi nti amaloboozi ago bagawuliriza. Obuzibu obuli ku General Court Martial nga bwebadde, be beemulugunya ne bakutwalayo mu kooti yaabwe, be bakuwozesa prosecution, ate nga ab'amagye be batudde wali be balina okusala omusango guno. Kwegamba nga tewali bwenkanya buli mu nsonga eno. Kirungi nti ensonga eno egenda kutereezebwa. Ate ekirala kooti kyekoze nti teyambye just bannansi ensonga eno okutereera n'ab'amagye nabo, kubanga ab'amagye nabo babadde batulugunyizibwa nti oli w'amagye, oli private, onyiziza mukamawo meja oba kapiteni oba ki, n'akutwalayo just olwokubanga omunyiziza, ne bakusalira eyo emisango egitategeerekeka, oluusi n'okutwala kalabba. Kati n'ab'amagye nabo bafunye obuwolero lw'ensonga eno. Katusuubire nti ekiragiro kya kooti kino kigenda kuteekebwa mu nkola bunnambiro, kubanga ebiragiro bingi ebya kooti ebizze binyoomebwa. Kooti nega nti omuntu ono tumutadde kakalu ka kooti, ne baddamu ne bamusiba nga tannafuluma na geeti ya kooti, n'ebirala bwe bityo. Katusuubire nti ekiragiro kino kigenda kuweebwa ekitiibwa, kiteekebwe mu nkola.
For democracy, for the rule of law, and for constitutionalism in this country. And as Honorable Segona said, I think it is evidence that if you continue struggling, there are some small wins. We live under a military dictatorship, but there are small wins here and there. And like we always say, the struggle can be everywhere. Our parliamentary teams will do their work there. People, lawyers will go to courts. Others will go on the streets. Every bit contributes to the struggle for better governance, for democracy, our pursuit for a better country. So for us as NUP, we are very, very delighted today, because as you know, the military court has been used to persecute, not to prosecute, but to persecute over 2,000 of our supporters since 2020. Over 2,000 of NUP supporters have gone through that court. Because that is, and I mean, I shouldn't even be calling it a court, because the Supreme Court has clearly said it does not. It is even not a tribunal. It is something just there. So we are very glad, and we salute our comrades who refuse to plead guilty. those 9 people who refused to plead guilty. We have Bobby Young, who is still in detention, and many others who are still facing charges. Our comrade Achileo is still facing charges before that military court, and others. So we are very glad with this ruling. We hope, like my brother Lop said here, that General Museveni will now not devise means of trying to defeat this court ruling. But also this is a win for the people of Karamoja. Every time you go to Chitalia, you find hundreds of people from Karamoja who are taken to those military courts without any trial, and then taken to Chitalia. They spend there years and years without trial, without even going back to court. Onako lwaleero fenga NUP tulaya court ensukulumu gwanga. Ngabo tuze tubagamba nti struggle buli omu holi osobola okukolerawo struggle. Banamateeka bagenda mu courts, ababaka ba parliament ne bakolera eyo, n'awalala abamu ne bagenda ku street n'ebirala. Eyo struggle basebo ne banyabo. Era olunaku olwaleero twagala kwebaza banamateeka awadde bagoberera ensonga eno. Kooti ensukulumu yakyogedde bulungi nnyo nti eyo si kooti, era abantu baffe ababulijjo tebalina kukozesebwa mu kooti eyo. Era nekyogerako bulungi ne banamagye abawozesebwa balina okuba n'eddembe lyabwe, si kubatuusayo ne babatulugunya ne babatuusako obulabe babadde batuusaako. Twagala kwebaza bakomuledi baffe 9 abaagana kukkiriza emisango gye batazza. Mujjukira bulungi Balamu ng'akolera ku biragiro bya Museveni yagenda n'aperereza abawagizi baffe abamu 19 ne bakkiriza emisango gye batazza. Naye 9 mu bo ne bayimirira ne bagamba ffe tetugenda kukkiriza emisango gye tutakola. Era bwe baba batulaba olunaku lwaleero Kitalya tubeebaza bazira baddala. Fenga NUP bukya mu mwaka gwa 2020 abantu baffe abawera ddala 12,000 bayise mu kooti y'amagye. Mujjukira abantu baffe be bajja Kalangala ba Edi Mutwe banubiyanirira abalala babatwala eyo kooti y'amagye ekibadde kigifuula nga si kooti nga byekola tebiri mu nansa completely. Ne bagamba nti babasanga n'amasasa simanya 2 ekavule. Abantu 49 n'obateeka ku kisango bwe kityo ne babasiba emyezi 7 kakati ne batwala abaana baffe abalala abamaze emyaka 4. So tuli basanyufu n'ensala ya kooti eno, era abaana baffe tubeekalikinga kati bereeti tugenda kuzambalira ddala kubanga badde batya kwambala bereeti zaffe nga batya kooti y'amagye. Twabagamba bereeti zaffe si z'amagye, ovolo zaffe si z'amagye. Kakati engeri kooti y'amagye kooti ensukulumu bwekyogedde bulungi nnyo teri si kooti. Tusuubira nti ate temugenda kuddamu kukwata abantu baffe abambala zi bereeti abambala zi ovolo zaffe n'ebirala. Kati tusimbudde, mwebale nnyo.
Omusumba ye n'asaba n'agamba bagawugule gagende wabafuluma 13
era mbyagalira ddala pulezidenti wange
betwasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka eza paka kulira